This is Vijay from CLAT 100, and here in this session, we are going to discuss all 12 legal reasoning questions that were asked in SLAT 2023 on 6th of May. It's important for those people who took this test because they can straight away calculate their scores. It's very important for those people who are appearing for SLAT on 14th of May. It's certainly important even for those people who might take this test in year 2024 and the subsequent years. Here is your first question. Abhigyan unlawfully detains Suyosh, son of Akash Govil, in order to coerce Akash to enter into an agreement. Now, here you do not have any legal principle. So, using your legal knowledge, you know that the moment any coercion is involved, any such contract becomes voidable. Isn't that? So, this is certainly a voidable agreement, and this can be rendered void on the behest of Akash Govil. Alright, why? Because he is the person who was coerced. Look at this question. A person making any gesture or preparation thereby causing apprehension in the mind of the other person present that he is going to use force against that person is said to have committed assault. Usual definition of assault, isn't that? Now, let's look at the fact. Chandu, while standing on the terrace, mind you, on the terrace of his bungalow, shows his fist and abuses Rishi, who is passing in an auto rickshaw. And hey, if you do not pay attention to me, I'll give you a big punch on your face. Is it an assault? Did I create this apprehension in your mind that I could hit you? No. You're very well aware that I'm only on your screen, not in front of you. If this was not an assault, Chandu standing on the terrace of his bungalow showing his fist to someone who is traveling in an auto rickshaw could also not be an assault. Why? Because a person traveling in an auto would not have this apprehension that he could be hit by Chandu. So, this is certainly not an assault. Isn't that? So, here the answer is Chandu has not committed assault against Rishi. Tia, 5 years of age, while playing with her friend Ankush, 5 years of age, pushes him, which results in serious injuries to Ankush's eyes and joints. Decide Tia's liabilities. Alright, first of all, the age of Ankush is irrelevant here. Alright, and all of us are aware of something that is called doli in capex. According to Indian law, any child who is less than 7 years of age cannot commit any wrong. Alright, what is the age of Tia? Tia's age is 5. So, we do not even need to read all the options. Tia is not liable and can claim the defense of doli in capex. Is that very clear? Sections 85 and 86 of the Indian Penal Code prohibit the use of voluntary intoxication as a legal defense. Mind you, voluntary intoxication. Alright, Jack is a habitual drunkard. Okay, so indication is that in his case, the intoxication is voluntary, not that someone comes and thrusts a bottle in his mouth, alright, to intoxicate him. He is in possession of a bottle of medicine for internal use and a bottle of deadly lotion for external application, alright. He gives his son 1 spoon of medicine that was meant for external use, sad, while he was intoxicated, which caused death to his son, alright. Is Jack accountable for any crime? Let's read the options one by one. He is not at fault because he committed the crime while he was intoxicated. Option D. Now, the principle says that if the intoxication is voluntary, right, it cannot be used as a defense. So, this is definitely incorrect. Jack has committed a murder. Come on, for murder, mens rea should be there. He certainly did not intend to kill his son. Right, so this cannot be the answer. He would never intend to harm his son, hence he is innocent. Irrelevant, isn't that? Why should I even be reading the first option? That is the answer. He committed a careless deed that resulted in his son's death. Yeah, true. So this is your answer. No man accused of an offence can be compelled to give evidence against himself. In Indian Constitution, there is your Article 23. Isn't that? That is straight away given here. Mohit is working as a gardener at Saket's residence. While Saket was away on an office tour, his residence was burgled and Mohit has been absconding since then. So police has all the reasons to apprehend something. Police collected some fingerprints from the door of the house and from the gardening equipment. Upon suspicion, police went to Mohit's residence and forcibly took his fingerprints. Choose the correct derivation. Mohit's fingerprint should not be taken on the basis of speculations. I would say this option is irrelevant, right? Mohit's fingerprint cannot be taken against his will, has already been taken. Okay, why it cannot be taken? Okay, that reason is not given here. Mohit's fingerprint can be collected by the police because that does not amount to testimony compulsion. Absolutely. So that's the answer. Option C. Arun and Yogesh, two brothers, were quarrelling over the distribution of their father Mr Vinod's property. Alright. Their mother Vinita persuaded Arun to give up his demand and promised she would pay 20 lakh rupees to Arun if Yogesh fails to pay 20 lakh rupees to Arun. Okay, then we have to decide whether it's a valid contract or whatever, whether it's enforceable or not. Alright, please listen to each and every word very carefully, and this time I'm not going to give you any fist, right? So here, our question, what is the consideration for Vinita? The consideration for Vinita is Arun giving up his demand. It's a valid consideration. What is the consideration for Arun? That is Vinita's promise that if Yogesh fails to pay 20 lakh rupees to him, the mother would. Alright. So there are valid considerations. Alright. So Vinita's promise is enforceable by law. Easy peasy. Option A. Indian Young Lawyers Association and others versus the State of Kerala and others is popularly known as, I'm sure everyone taking the test would have got it right, Sabri Mala Temple case. And if you didn't, it's a matter of concern. Hey, what is the actual name of this triple talaq case? You remember? And what is this judges transfer case? What is three judges case? Please, before you appear for the next SLAT, you must know options A, B and D as well. Now you already know C. Alright. Okay. A enters into a contract with B wherein B is supposed to supply A with goods on 10th November 2020. However, B suffers issues in procuring the goods due to the strike, and because of a sudden rise in the price of the goods, he is unable to deliver it on the date. Can B take the defense of force majeure? Alright, can he? First of all, is a strike unforeseeable? Is it? Unforeseeable? Can you foresee it? Can you? Sudden rise in the prices, is that also unforeseeable? The answer is option D. No. Such situations of disappointed expectations cannot be covered under force majeure. Isn't it very clear? Okay, so the answer is D. No. Assertion, governor is bound to act on advice of the council of ministers. Till here it's absolutely alright. But beyond this, in the appointment of the chief minister. So if the chief minister is yet to be appointed, you do not have the council of ministers. In the worst case, you would have a caretaker government. Alright. So this assertion itself is incorrect. Undoubtedly, did you pay attention to this? In the appointment of the chief minister, taking advice from the council of ministers. Alright, not possible. So this is certainly incorrect. Now, Article 163 imposes an obligation on the governor to act on the aid and advice of the council of ministers similar to Article 74. Article 74 in case of the union, right? 163 in case of the state executive, right? So, of course, this is absolutely alright. This is incorrect, and hence your answer is option C. Reasoning is correct, but assertion is not correct. How many of you got it right? Alright. Removing things from the possession of another with dishonest intention is theft. In order to have his wool jacket dry cleaned, Aman gives it to a dry cleaner. Alright. After 2 days, he is asked to pick up the garments, but he realizes that he did not have funds to pay to the dry cleaner. Alright. He secretly lays the jacket near his other things So he may stealthily grab it without the dry cleaner noticing it. This answers your question. Stealthily grab it. Because it's winter and he really needs the jacket. Is Aman guilty of any crime? Let's read the options one by one. Aman is not guilty because it is winter and he really needs the jacket. Legally irrelevant. Even if you sympathize with Aman, the fact is that legally this is irrelevant. Aman is not guilty because the jacket belonged to him only. Alright. Does the principle talk about ownership or possession? It talks only about possession. So who was in the possession of the shirt? It was the dry cleaner and not Aman. It's not about ownership. So we can rule this out. Aman is not guilty of theft because he intends to pay the money the next day. Again, completely irrelevant, right? So I do not even have to read the first option. Aman is guilty of theft because he moved it in order to take it out of the possession of the person, the dry cleaner. Right? So, of course, your answer is Aman is guilty of theft because he moved. Company DLF Limited is accused of violation of the Consumer Protection Act 1986 by selling defective products. According to the principle of consumer sovereignty, what is the company's liability in this case? Alright, the company is liable for any harm caused by the defective products regardless of the intent. True. The company is not liable only if it can prove that it took steps to prevent harm. The company is not liable as consumers should have been more careful. Completely irrelevant. The company is not liable if it can prove that consumers misuse the product. So, A and B are anyway completely irrelevant. Alright. The company is not liable only if it can prove that it took steps to prevent harm. But you will take steps to prevent harm if the product is defective. Right? So this also indicates this. Taking steps to prevent the harm would not help you. Answer is D. A is driving his car and hits B who is crossing the road. B suffers injuries and is hospitalized. Can B sue A for compensation? And read each and every option very carefully. No, because he should have been more careful while crossing the road. That is, B should have been more careful. How do we know whether he was careful or not? No, because A follows the traffic rules. Do we know? No, we do not. So this also cannot be the answer. Yes, but only if we can prove that A was driving negligently. Alright, rash and negligent act. So this appears to be your answer. Let's read the fourth option as well. Yes, because A hit B while driving his car. If you are not being rash and negligent and you unfortunately hit someone, why should you be booked? So this also cannot be your answer. So answer is option C. Alright. And hey, we have put lots of content for SLAT. In fact, as many as 26 tests. Your test is on 14th of May. So please be on our Telegram group and do all those tests. Alright. And if you like this effort, please give us a thumbs up. Share it with as many people as possible. Subscribe to CLAT 100 if not already done. And press the bell icon hard, so that we keep you updated on whatever we do on our YouTube channel and elsewhere. All the best.